I'm going to ask you about child support. So again, do we have a definition of child support? Why?
Well, first of all, I guess what you do is you look under both the Divorce Act and the Family Law Act.
Okay.
They very, very clearly both set out that if you are in a common law or, well, under the Divorce Act, if you are married, or if you are either married or in a common law situation under the Family Law Act,
Yeah.
if there's a child born of that relationship, both parties have an obligation to financially support any child in the relationship to the best of his or her abilities. So that's the basic premise and starting point, that if there's a child of the relationship, and it doesn't have to be a child born of the relationship, it applies to a child who's adopted. It can even apply, and it does apply to, let's say, if you're dealing with someone who's been either married or in a relationship before and has a child, and they move in with somebody, either married or not getting married to this other person, and they bring that child with them into that relationship.
Mm-hmm.
If the new spouse, either common law or married, treats that child as a child of his or her own child and acknowledges through the course of the time that they're together that they're treating that child as a child of their own, in the event that second relationship breaks down, the second spouse will have an obligation to pay child support as well, even if the child may not be biologically that parent's child.
Wow. Okay. That is not something that I think you would expect. Common
Support
sense.
is the child's right, and that's what
Right.
it is. The court's concern is to make sure that children are being looked after. And if you were responsible and looked after financially a child while you're living together, then the courts will say, well, you have an obligation to continue to support that child if you have the ability to pay after you've separated.
Like when it comes to parenting, child parenting time is what I want to talk about. So in a way, you can think of it as the child's right, but I tend to think of it as the parent right as well, because I know that I'm a mother, and I think I would be extremely upset if if I divorced and my spouse says, I don't want you coming near the child because you're such a bad influence, that kind of thing, right? So I would feel in that situation, hey, but wait a second, don't I have a right to see my kid? Like, so in that sense, I feel that parenting time is, yes, it's a child's right to see the parents, but isn't it also a parent's right to see their child?
All right, let's back up a little bit first, because when we were talking about child support is the child's right.
It's the child's right.
The law is very, very clear on that. So that just means that if a couple separates, the parent that is taking the child with them when they leave the relationship cannot say, look, as long as you promise never to see the kid again, I will never come after you for child support. Just leave us alone. You can't do that, because you cannot give away another person's right to child support. Okay, so let's talk about what happens. It's not as clearly specified saying that parenting time that the child spends with the parent is the child's right. But the language that is being used when you're talking about parenting time is what is in the best interests of the child.
Oh, okay.
So it's still, and again, now it's, and I might, I'll confess that I might trip occasionally here now too, because just as of March 1, 2021, under both the Family Law Act and the Divorce Act, when you're talking about kids, they changed the law. One of the biggest things that they did when they changed the law is they changed the terminology that it uses. Because it used to be that if you were together in a common law relationship or a marriage and you separated, then, and there are kids, the first thing that would have to be decided is who are the children going to be living with after the separation. So, and there could be, and that was called custody. And sole custody meant that the child would be primarily with one person. The other person would be entitled to access, which is time with the children that they don't live with on a full-time day-to-day basis. A joint custody situation would be one where the parties agree that they'll work together to make decisions that affect the child, and you generally see more of an even division of time. But it would still be, say, okay, there's joint custody, but the child will have primary residence with one parent to designate like really who is going to be that parent. And then the other parent would still have time schedules set out for the child. There could be shared custody where the parties say, well, okay, we're going to be doing this all together. We'll make decisions together. There won't be any child support paid one way or the other because we're both making about the same amount of money and the kids are moving back and forth freely, so you can do that. Then there was split custody, which is that when the child was with one parent, that parent would make all the decisions and whatever needs to be done with respect to that child while the child is in their care. But then when the child moved over to spend time with the other parent, and it would be, usually you're looking at a time, again, a situation where the time is pretty evenly divided, that when the child is with the other parent, then the other parent makes all those decisions and does it all as if it was there. But everything floated around that terminology. It was custody and access. And what they did is they changed the terminology as of March the 1st, where now you're talking about parenting arrangements. And parenting arrangements, you're looking at what is in the best interest of the child, and the legislation goes through a long list of things they look at for saying what is in the best interest of a child and what are the factors to consider and what you're looking at. But generally the way it's set up now is that parenting arrangements, the first thing that has to be determined is decision-making authority. Is it something that one parent is going to have or the other parent is going to have, or is it going to be shared decision-making authority? And then you have parenting time. So then you're talking about a parenting schedule. How much time is the child going to be spending with one parent as opposed to with the other parent? And there used to be something that was people thought was the actual rule, even though it wasn't technically written down, is that there was a provision that said that it was in the best interest of the child to have the maximum amount of time possible with each parent as was appropriate in that situation. They've taken that out. So now that they're saying when you're talking about parenting time, still the basic decision is what is in the child's best interest and what is best for the child and to how much time. And the whole point is that it's what's in the best interest of the child should determine how much time the child spends with each parent. And but still the assumption is, or the expectation would be, is that if both parents are equally capable parents, then if the parenting schedule is such that the child still lives more with one parent than the other parent, you're trying to still give that other parent as much time with the child as possible. But the whole point for changing that terminology was to take the win or lose out of there, saying, oh, well, I want sole custody. I won. I got custody. You've just got access. They've taken it out of there completely now. And they've made it very, very clear that they're talking about parenting arrangements and everything is really, really dependent on what's in the best interest of the child. It always has, but they've just made it a lot more clearer and given a lot more guidance as to the different factors that come into play on what is going to be deciding what's in the best interest of the child. Once you've worked out the parenting arrangements, and again, this is another conversation we had earlier about really when we've been talking about spousal support and property. The law and lawyers tend to talk about spouses, like husband and wife, or spouses or whatever, and how that's going to work. Once you start getting into talking about the child, you start talking more about parents, because you may not even be spouses. There could be a child that's born over a one-night stand. And they're still parents. And those parents still have the same rights as parents that are married or parents who are common law to have involvement in that child's life. Now, they will also have an obligation, if they have the ability to pay, to financially support that child through child support. But the rules are the same. Children have the same rights, whether they're coming out of a marriage, out of a common law relationship, or out of a one-night stand where there was no cohabitation relationship at all. Or even just a dating relationship, like their mom and dad might have never lived together, but they could have still been in a long-term relationship, but they just kept separate houses. If there's a child born, rights to the parent and the rights of the child are exactly the same.
Is there such a thing as retroactive child support?
Yes.
Oh, wow.
How successful you'll be on that claim, though, again, will depend on the individual fact situation. One of the things that courts will look at is if there has been a real substantial delay in going back and claiming support. There might have even been an agreement up front, which is like the one that I talked about, where the parents agree that this child's birth was not meant to happen and that they don't want to parent together, and the sperm donor just says, I don't want a relationship with that child, and she says, okay, fine, just don't darken my door and I won't come after you for child support. Courts have overturned those agreements, and when the mothers come back, because it is the child's right to child support. How much support would be made to be paid retroactively and whether they will in fact order it in the first place is going to depend on each individual fact situation, and what your lawyer's advice to you are going to be will be very, very important, but it is possible, yes.